We know disagreements about custody and visitation are very common at the beginning of a divorce and separation process, but that doesn't mean you can or should keep your children from seeing their other parent. I'm Jenny Bradley, owner of Triangle Smart Divorce in Cary, North Carolina. Unless the court tells you otherwise or you have an agreement in place, both parents have equal decision-making rights as well as physical access to their children during separation. As a married couple, you shared custody of the children. That doesn't change because one parent left. If your spouse moved out of the house, you should not stop your children from seeing them. It doesn't matter how much of a jerk your spouse has been or how angry or hurt you are. So long as there's no physical or substance abuse going on, you need to support the other parent's relationship with the kids. Whatever's going on between the parents shouldn't affect a child's right to have a relationship with both parents. We tell our clients that trying to hurt your spouse will end up hurting your case in the long run. If you don't allow your spouse to see the children, it can and most likely will be held against you in court. The other parent might end up getting more time with the children than they would have otherwise. Courts look favorably upon parents who encourage a positive relationship with the other parent. Now, if you have legitimate fears for your child's safety, there are things you can do within the legal system so that you have the right to keep the children from your spouse. These situations are very complex, and you need to seek legal help as soon as you can to protect your children. So, if you are getting ready to separate and you're the one who's decided to move out, what should you do to make sure you have access to your children? In a perfect world, parents who know they're going to separate would create a written agreement before one of them moves out. But we understand, this just can't happen in every case. And some people don't even contact a lawyer until after they've moved out. In North Carolina, there is a year separation period that has to be observed before you can file for divorce. You do not have to wait a year to file for custody, though. If you come to an agreement with your spouse, you can start following it right away. Sitting down and negotiating a parenting plan that works for everyone is almost guaranteed to pay off in the long run, monetarily and in time and effort saved, but most importantly, for your children's well-being. We know that children thrive on structure and stability, so getting into a regular routine as soon as possible is best for them. That being said, if you cannot agree on custody and visitation, you can file a custody action with the court to figure it out. This is going to be a time-consuming and expensive process, but it will end with a custody plan. It'll just be a plan that was decided on by a judge and not by you and your spouse. And in the case of temporary custody orders, it'll be a plan based on very little testimony and evidence, as these hearings are typically limited to 2 hours total. Think about that. A judge will only hear 2 hours of testimony before they decide one of the most important things in your life: how parenting decisions will be made and who will get to see the kids when. Because we think two parents know better than any judge. We always try to encourage working out custody issues with your spouse before going to court. Even if you're on great terms with your spouse, you need a lawyer to help you paper your plan, so your agreement and consent order will hold up in court if you need it to. At Triangle Smart Divorce, we have decades of experience helping families figure out what's best for their situation and making sure a fair agreement is put in place. Give us a call.